A federal court decision just set up the biggest constitutional challenge to red flag gun laws in American history, and the Department of Justice, along with 25 state attorneys general, just filed briefs supporting a case that could eliminate these laws nationwide. If you own firearms and live in one of the 21 red flag states, this case could determine whether your guns can be seized based on accusations alone. Before we dive in, subscribe immediately. Why? Because this case is moving through federal appeals courts right now. Most gun owners have no idea it exists, and the outcome will directly affect whether you can lose your firearms based on someone else's word. Click subscribe, because this legal battle could reshape Second Amendment law forever. Here's what's happening, and why it's the most important gun rights case since Heller and McDonald. The case is Caniglia versus Strom, and it's working its way through the federal court system with a simple but explosive question. Can the government seize your firearms based on someone's claim that you might be dangerous without criminal charges, without a criminal trial, and without the constitutional protections that apply to criminal cases? 21 states say yes. The Department of Justice and 25 state attorneys general say no, and the Supreme Court will likely have the final word. Here's the mistake that has allowed red flag laws to spread across America unchallenged. People think these laws only affect dangerous individuals who shouldn't have guns anyway. They think red flag laws include strong due process protections. They think you have to do something clearly threatening before your guns can be taken. All of that is wrong. Red flag laws, officially called Extreme Risk Protection Orders or ERPOs, allow courts to order the temporary removal of firearms from individuals who may present a risk of harm to themselves or others. The key word is may, not will, not have, but may present a risk. The legal standard in most red flag states is preponderance of evidence, meaning it's more likely than not that you might be a risk. That's a much lower standard than the beyond reasonable doubt required for criminal convictions. You can lose your constitutional rights based on a coin flip level of certainty, but here's what makes these laws constitutionally dangerous. They operate entirely outside the criminal justice system. No criminal charges, no criminal trial, no right to a jury, no right to confront witnesses, no right to cross-examine accusers, no presumption of innocence. Someone makes an accusation, a judge reviews paperwork, your guns get seized, you find out after it happens. Let me walk you through how this actually works in practice, because the reality is far different from what advocates claim. In California, family members, law enforcement, employers, co-workers, teachers, and healthcare providers can petition for an ERPO. The initial order can be granted without you being present, without you being notified, and without you having any opportunity to defend yourself. Within 24 hours, law enforcement shows up at your door with a court order to seize all your firearms. You can request a hearing to get them back, but that hearing might not happen for 2 weeks. At that hearing, you have to prove you're not dangerous. The burden is on you to prove a negative. If the order is continued, you could be disarmed for up to a year. If someone files a new petition, the process starts over. There's no limit to how many times you can be subject to these orders. Now here's where the constitutional challenge comes in. The Caniglia case involves a Rhode Island man whose wife called police during a domestic argument. She claimed he was suicidal and mentioned his guns. Police conducted a community caretaking search, seized his firearms, and held them even after determining he wasn't actually a threat. The First Circuit Court of Appeals ruled that police acted properly under their community caretaking function, but the Supreme Court disagreed. In a unanimous decision in 2021, the court held that the community caretaking exception doesn't allow warrantless home searches for firearms. That decision didn't directly address red flag laws, but it established a crucial principle. The government's interest in public safety doesn't automatically override Fourth Amendment protections when firearms are involved. Now, multiple federal challenges to red flag laws are working through the courts, and they're all raising the same constitutional questions. Do these laws violate due process? Do they violate the Second Amendment? Do they violate the Fourth Amendment's warrant requirement? The Department of Justice, under previous administrations, defended red flag laws, but in recent briefs, DOJ has argued that these laws, as written and implemented, violate multiple constitutional provisions. 25 state attorneys general have filed briefs supporting challenges to red flag laws, arguing that they create a dangerous precedent for seizing constitutional rights without adequate legal protections. Here's what the law does not protect you from under current red flag statutes, and this is terrifying. The law doesn't protect you from false accusations. If someone wants to disarm you temporarily, they can file a petition with minimal evidence. Even if the petition is eventually dismissed, you've lost your firearms for weeks or months while fighting the order. The law doesn't protect you from biased judges. ERPO hearings are often brief, one-sided affairs where judges err on the side of caution by continuing orders rather than risk being blamed if something happens after they return guns. The law doesn't protect you from permanent consequences of temporary orders. Even if you get your guns back, the existence of an ERPO creates a record that can affect future gun purchases, concealed carry permits, and security clearances. The law doesn't protect you from the costs of fighting false accusations, legal fees, time off work, and the stress of defending your constitutional rights, all because someone made an accusation. And most importantly, the law doesn't protect you from the fundamental injustice of having to prove your innocence rather than the government proving your guilt. Here's the constitutional framework that challengers are using to attack red flag laws. First, the Second Amendment argument. The right to keep and bear arms is an individual constitutional right. Under Heller and MacDonald, the government cannot eliminate that right without compelling justification and careful procedural protections. Red flag laws eliminate the right temporarily based on speculation about future behavior. Second, the due process argument. The 14th Amendment requires fair procedures before the government can deprive you of constitutional rights. Criminal defendants get attorneys, jury trials, and proof beyond reasonable doubt. Red flag subjects get a brief hearing where they have to prove they're not dangerous. Third, the Fourth Amendment argument. Seizing firearms from homes requires warrants based on probable cause. Red flag laws allow seizures based on lower standards and often without traditional warrant requirements. The federal courts are split on these questions. Some circuits have upheld red flag laws, arguing that the government's interest in preventing violence outweighs individual rights concerns. Others have found constitutional problems with how these laws operate in practice. That circuit split makes Supreme Court review almost inevitable. Here's what the case law suggests about how the Supreme Court might rule. In recent Second Amendment decisions, the court has emphasized that constitutional rights cannot be eliminated based on speculation about future behavior. In recent due process cases, the court has required meaningful procedural protections before the government can seize property or restrict rights. The court has also shown skepticism of government arguments that public safety automatically justifies reduced constitutional protections. But here's what makes this legal challenge particularly strong. It's not just about gun rights. Red flag laws create a template for seizing other constitutional rights based on accusations and low evidentiary standards. If the government can take your guns because someone says you might be dangerous, what stops them from taking other rights the same way? Free speech rights because someone says your words might incite violence? Privacy rights because someone says you might be planning something harmful? The constitutional principles at stake go far beyond firearms. But here's what red flag opponents need to understand. Winning these cases requires more than just arguing that the laws are bad policy. It requires showing that they violate specific constitutional provisions in ways that courts can clearly identify and remedy. The strongest arguments focus on procedural due process. The idea that before the government can take your constitutional rights, it must provide fair procedures that give you a real chance to defend yourself. Current red flag laws fail this test. They allow rights to be taken based on one-sided hearings, low evidentiary standards, and procedures that favor seizure over protection of rights. Here's the safe boundary principle for anyone living in a red flag state. Assume these laws can be weaponized against you and plan accordingly. Document your mental health. If you've ever received counseling, therapy, or treatment, keep records showing you're compliant with treatment and not dangerous. Create a paper trail of responsible behavior. Be careful about domestic disputes. Many ERPO petitions arise from family conflicts. If you're going through a divorce, a custody battle, or any kind of domestic dispute, understand that ERPO laws give the other party a powerful weapon against you. Avoid social media posts that could be interpreted as threatening or concerning. Even jokes, movie quotes, or political statements can be taken out of context and used as evidence in ERPO proceedings. Build relationships with people who can speak to your character. If you're ever subject to an ERPO petition, you'll need witnesses who can testify that you're not dangerous. Know your state's laws. Understand who can file petitions against you, what evidence they need, and what your rights are in the process. But even perfect compliance with these principles doesn't guarantee protection. Red flag laws are designed to err on the side of seizure rather than protection of rights. Here's what the federal constitutional challenge could accomplish, if successful. It could establish that Second Amendment rights cannot be taken without criminal-level due process protections. It could require higher evidentiary standards for firearm seizures. It could mandate that gun owners get the same procedural protections as criminal defendants, or it could go further. Some challengers argue that red flag laws are fundamentally incompatible with constitutional rights because they punish future behavior that hasn't occurred and may never occur. The Supreme Court has never directly addressed this question. Can the government take constitutional rights based on predictions of future behavior? If the court says no, red flag laws nationwide could be struck down or severely limited. If the court says yes but requires stronger procedures, the laws might survive but become much harder to use against law-abiding gun owners. But if the court upholds these laws as currently written, it could signal that constitutional rights are much weaker than most Americans believe. Here's the timeline you need to understand. Multiple red flag cases are currently in federal appeals courts. At least one is likely to reach the Supreme Court within the next 2 years. The court's decision could come as early as 2026. That decision will affect not just the 21 states that currently have red flag laws, but the entire constitutional framework for how government can restrict rights based on risk assessments. Every gun owner in America has a stake in this outcome. Even if you live in a state without red flag laws, the constitutional principles established in these cases will affect other areas of gun law and constitutional law generally. The federal challenge to red flag laws represents the biggest test of Second Amendment rights since the landmark cases that established individual rights to firearms. It also represents a major test of due process rights and the limits of government power to restrict constitutional rights based on speculation. 25 state attorneys general and the Department of Justice have lined up behind the constitutional challenge not because they oppose reasonable gun safety measures, but because they recognize that red flag laws, as currently written, violate fundamental principles of American law. The outcome will determine whether constitutional rights can be taken based on accusations and risk assessments, or whether the government must meet traditional criminal law standards before seizing rights. For gun owners, the stakes couldn't be higher. A loss could mean that anyone can be temporarily disarmed based on minimal evidence and unfair procedures. A win could mean that constitutional rights get the strong procedural protections they deserve. The case is moving forward. The briefs are being filed. The constitutional showdown is coming. Your rights are on the line. Remember, this is educational information about ongoing constitutional challenges to red flag laws. This is not legal advice for your specific situation. If you're subject to an ERPO or facing similar legal issues, consult immediately with a qualified attorney who specializes in firearms law and constitutional challenges. The law is complex, the stakes are high, and the outcome will affect every gun owner in America.